Welcome everyone to the 5th informational webinar as part of the UNCITRAL Working Group 3 process on investment arbitration reform. My name is Malcolm Langford. I'm a professor at Pluricourts, University of Oslo, and chair the ISDS Academic Forum. The Academic Forum is a diverse and inclusive forum of almost 100 scholars from across the world with expertise in international investment law and other relevant systems. We seek to provide a relevant research-based analysis to states and observers in Working Group 3, as well as providing independent critical analysis. Today's theme is the role of mediation. And I will not, though, be your moderator today due to a clash in commitment, and Jae-sung from the UNCITRAL Secretariat will moderate most of this online meeting, along with Catherine Kassetjan from the Academic Forum. A few technical things. We now use the webinar version of Zoom, which is a little different from the normal Zoom. So only the videos of those who present on the panel and ask questions will be shown. 3 practical things. Firstly, if you wish to speak and ask a question, put up your hand in the participants function and you'll be promoted to panelists, and that'll be relevant to the public discussion that we'll have after the presentation and panel. Secondly, if you wish to ask a written question, you can do so in the Q&A section or in the chat section. Finally, the meeting will be recorded and posted on YouTube an hour or 2 after the event, but you'll only be shown if you present on the panel or ask a question orally. Without further ado, I'd like to hand over to Anna Jubinbrett, the Secretary of UNCITRAL.
Thank you very much, Malcolm, and welcome to all the participants and to our panelists for this afternoon's webinar on mediation in the investor-state dispute settlement context. This webinar is part of a series that has been organized by my colleagues here in the Secretariat together with the Academic Forum as part of the topics that were identified for either side events or for discussion and deliberations during the working group session that was supposed to take place in April and that is being postponed now to the month of October. Before I give the floor to the panelists and to enter into the actual discussion of mediation, I wanted to do a bit of publicity for the forthcoming events. We will have a series of consultations based on webinars relating to the code of conduct that the UNCITRAL and ICSID secretariats have been working on together, and that is now available on our respective websites. The idea of these webinar consultations is really to encourage, first of all, to introduce the code of conduct and to encourage those who participate to give us comments on this draft before it goes to the next to a forthcoming working group session. There's also another webinar that is planned on the 2nd of July on a topic that had been identified already for joint work between the UNCITRAL Secretariat and the OECD on reflective loss. This is taking place on the 2nd of July. Everything is available on our website, so don't hesitate to go there for further information. The commission session is most probably going to start in a completely virtual format on the 6th of July. It will take place in a virtual format from 6th to 17th of July with some very focused webinars that will cover the COVID-19 pandemic and the response and recovery, how it can be supported by UNCITRAL text. So they will be really focused on this particular aspect. And the session will then resume in September from 8 to 14 of September, sorry, from 14 to 18 of September, I should know it by now. From 14 to 18 of September, and there we are still not 100% sure that the session will be in person only, but we are still working on it with our member states. Consultations are ongoing. So with this and with this to advertise, it gives me great pleasure to meet and greet all of our panelists that are joining us today. Some of them that are really old friends and participants in efforts to promote mediation in the context of investor-state disputes since many years, and I'm particularly looking at my partner in crime, Bart Legum, with whom we put together many years ago a first set of rules on investor-state disputes mediation. And so it's really with a particular pleasure that I'm opening this webinar that is devoted to our dear investor-state mediation. But without further ado, let me give the floor to the Secretary of Justice of the Hong Kong SAR, Ms. Teresa Cheng. Teresa doesn't need an introduction for those of you who are active in the arbitration and mediation world, but her participation today with us is particularly focused on the proposal that was given to the working group that came from the People's Republic of China to host an intersessional meeting in Hong Kong during the first week of June 2020. So we have obviously missed the date, but for good reasons. It had to be postponed, and it was one of the proposed topics for discussion at the intersessional meeting to look into investment mediation, the topic of today's discussion. So without further ado, I give you Teresa Cheng, Secretary for Justice of the Hong Kong SAR of the People's Republic of China. You have the floor. Thank you.
Thank you very much, Hannah. Can I say what a great pleasure to be here speaking to a group of experts, and no doubt the panelists as well as those who we can't see on the screen but are watching through the webinar. Let me just try and do a bit of promotion here, because I want to follow on from what Anna said, and that is to give you some idea of what we're thinking about in the intersessional meeting. With the support of the Central People's Government of the People's Republic of China, Hong Kong SAR has a great honor to host the intersessional meeting on the 9th and 10th of November here in Hong Kong. And this is the first time the working group of UNCITRAL will be meeting in Hong Kong SAR, and so it's a very exciting time for us. So therefore, notwithstanding that we have to postpone it, we are very pleased that we're able to fix a date now. And of course, in the light of the uncertainty surrounding COVID-19, we are now exploring to adopt a hybrid mode for this intersessional meeting. That is, we'll try and have a physical as well as an online session. Probably, again, the first time for such hybrid mode to be adopted for an intersessional meeting. And I hope that this is going to work, and we'll work out a little bit more details later together with the UNCITRAL Secretariat, and they will be circulated to all of you later on. ISDS reform, naturally, this very subject that this working group is looking at, is important internationally, but also very close to the heart of Hong Kong people. Hong Kong is a global investment hub and a springboard for inbound and outbound investment into and from mainland China. And under the one country, two system, we have, as authorized under the basic law, entered into 22 investment protection and promotion agreements with 30 foreign economies so far. And of course, we continue to do that, and of course, participating in a lot of the Working Group 3 work as member of the Chinese delegation. Investment mediation will be the theme for the intersessional meeting. States and observer delegations from the Working Group 3 have shown much interest in this great subject, and this investment mediation as an effective, efficient, and flexible dispute resolution mechanism, I think, should be carefully studied and looked at and developed. Mediation, though not a panacea, can complement the structural reform options such as the ISDS appellate mechanism, operating together, if I may call it a quote-unquote double helix approach to pursue both structural and non-structural reform for ISDS. Let me just tell you what we're thinking about the intersessional meeting, the theme, and how we're going to go about it. On day one, we suggest that the expert panels on the use of mediation of ISDS being adopted, and state delegations and well-renowned experts like your good selves, we hope that we'll be able to gather all of you together to share insights and experience on some of the topics. Now, at the moment, we thought about 4 topics and we're still finalizing it. For example, we can look at overcoming challenges to the use of mediation in ISDS. We're thinking of possibly states, how do we encourage more states to be involved? We then want to talk a little bit about the multi-tiered dispute resolution process, how do we develop a protocol of some sort? Thirdly, we suggest to look at the hybrid models of arbitration and mediation, something that may well be worth exploring in order for an efficient mechanism to be developed. And lastly, to look at the way forward for mediation as an ISDS reform option, because having got the ideas, we have to put, as it were, pen to paper or put it into action. So that's what we're thinking of doing. And these ideas really were drawn from the working paper WP 190 prepared by the UNCITRAL Secretariat. So we've sort of taken some of those views on board in order to put together those topics. So that's for day one. On day two, what has been done, and we're adopting the same general format, and that is to have a closed door roundtable discussion for delegations of the Working Group 3. And that will allow more in-depth exchange of views and suggestions on the possible mediation-related reform options. And we hope that these 2 days of discussion will be crystallized into a report for reference and consideration by the Working Group 3. So I think in a nutshell, I try and give you some thoughts of what we are planning to do. And of course, I look very much forward to seeing you all in Hong Kong. And of course, in the meantime, do stay healthy and do stay safe. We hope that the pandemic will be under control and we will be in a new normal. But thank you very much.
Thank you, Secretary Cheng. Now, we also look forward to actually the intersession also in Hong Kong. Next, I would like to give the floor to Ms. Natalie Morris Sharma, the former chair of Working Group 2 and current rapporteur for Working Group 3, to give some preliminary remarks on the mediation framework in the context of ISDS. Natalie, you have the floor.
Thank you very much, Jay. And it's really my honor to be addressing everyone in my capacity as rapporteur of Working Group 3. This webinar, organized by UNCITRAL on the topic of role of mediation in ISDS, is, as we all know, like the other seminars in the series, intended as an informational platform to complement our work in the working group, especially since currently physical meetings are not possible. The full set of my remarks have been circulated and made available to you, and in essence, I would like to speak to the growing interest of mediation in ISDS. The role of mediation or conciliation in ISDS, the 2 terms being interchangeable for our purposes, may not be large now, but by all accounts, it is set to grow. First, in our working group papers, submissions, and discussions thus far, questions regarding dispute prevention and mitigation, specifically ADR methods such as mediation, have been consistently raised as a common theme of interest. And as Madam Cheng mentioned, mediation offers the promise of effective, efficient, and flexible dispute resolution. Mediation can be used as a tool to prevent disputes from emerging or from escalating to a formal dispute, a formal investment dispute. In the event of a formal dispute, mediation enables disputing parties to clarify and crystallize the issues and the dispute. And also, it offers a higher degree of flexibility and autonomy to disputing parties, who can then shape the way that disputes are resolved, including by agreeing on innovative solutions that would enable the longer-term preservation of their commercial relationship and of the foreign investment. Second, we see how the rules on mediation that can be applied to ISDS have been developed by various institutions, as well as by ICSID and UNCITRAL. And third, in the majority of existing investment treaties, mediation may not be explicitly referred to, but that said, recent treaties have signaled possible new trends. We've, for instance, seen the introduction of frameworks such as annexes dedicated to mediation as a complement to the option of investor-state arbitration, for example. Fourth, there has been favorable reception on the part of investors of the prospect of mediation in ISDS, and evidence of this has been cited in the Academic Forum's concept paper on mediation in ISDS, which Anne Van Aken will be presenting on. My remarks on the growing interest of mediation in ISDS would not be complete without speaking about the conclusion of the Singapore Convention on Mediation, which is a recent product of UNCITRAL's work in this area. Following the conclusion of the Singapore Convention, we have seen an upsurge in the interest in mediation, including in the ISDS context. As Jay mentioned, I had the privilege of chairing Working Group 2 for this work that led to the Singapore Convention, as well as the 2018 Model Law on International Commercial Mediation. And as many of you know, the Singapore Convention on Mediation opened for signature on 7th of August. To date, we have 52 signatories from all regions of the world. It's been ratified by 4 countries, and so we will see the Singapore Convention enter into force later this year on 12 September 2020. A little bit about the convention, though I'm sure many of you know it well. In short, it is to mediated settlement agreements what the New York Convention is to arbitral awards. It will enable mediated settlement agreements to be enforced and invoked internationally, so long as the requirements of the convention are met. And in this way, it responds to one of the key obstacles that has been cited with regards to the use of mediation in a cross-border context, namely that the outcome of a mediation cannot be enforced internationally the way an arbitral award can. Already, the Singapore Convention has been taken into consideration by various mediation rules, such as ICSID's new mediation rules, which Froggy will take us through later. Admittedly, interest in mediation in the ISDS context aside, experience with mediation in ISDS is less widespread. And that's what today's webinar seeks to encourage to keep us doing, thinking about some of the important questions already raised in Working Paper 190, such as what are the specific characteristics and contexts of investor-state disputes we need to bear in mind, how and why would mediation be well placed to respond to such characteristics and contexts, what can we already learn from the use of mediation in the ISDS context, how can we promote further knowledge and capacity building, how can treaty dispute settlement mechanisms be designed to give room for mediation, how could mediation interrelate with other forms of dispute resolution, such as an ongoing or subsequent arbitration? How could government structures be designed to give room for mediation, and so on and so on? And these questions and more will be tackled by our presenters today. In addition to Anne and Frake, who I've mentioned, we'll also have the opportunity to hear from Arbit Bell, Deborah Masucci, Barton Legum, who will be introduced to you shortly. And I look forward to the thoughtful presentations, to your questions and comments, as well as to our further conversations on this issue in the working group once we're able to see each other again. Thank you.
Thank you, Natalie. I think you posed a number of questions that the presenters will need to actually address in their presentations. Now, before I give the floor to Professor Kasajian, I'd like to remind the attendees that if you have any questions or comments that you'd like to make, please make use of the functions, please make use of the Q&A or the chat functions that you see on the screen. If you'd like to speak after the presentations, please raise your hand and then we can promote you so that you can make the presentations once the panel discussion is over. So with that, I would like to pass over the floor to Catherine Kasajian to lead us through the discussions of the academic paper as well as the panel discussions. Catherine, you have the floor.
Well, thank you very much. It is my turn to welcome all of you to this joint effort by the Academic Forum and UNCITRAL on how to use mediation in the ISDS context. And perhaps I just want to add one idea that I think could be a red line in our discussions this afternoon. is that mediation is really there to change the mindset of disputes, to change the mindset of all actors in a divergent view of what is going on in an investment context. And in a way, it should be a continuation of the dialogue that should not be stopped between the state, the investor, and the other stakeholders in the field. As we are used to say in the mediation context, is that mediation is there to build trust. And I insist on that because it is really a very different mindset than what arbitration is doing, or for that matter, any court decision or procedure. In fact, we don't speak of procedure when we speak of mediation. We speak of a process, and the language is very interesting in that. But we also have a lot, as Natalie just said, a lot of flexibility, and we should build on that flexibility to build trust. Trust is not something that is imposed. Trust is not something that is there just as a given. Trust is something that you build among the parties, and that's what mediation is all about. So on this kind of overall theme, I would like to explain to you how we are going to build one stone after one stone, and you will understand in a minute why I'm speaking about stones. Anne Van Aken will indeed speak on the academic forum paper that we published actually just before the meeting that we were supposed to have in New York, and it was cancelled for reasons you know. Anne holds a prestigious chair at Hamburg University, the Alexander von Humboldt Professor of Law and Economics, Legal Theory, Public International Law, and European Law. And she's also the director of the Institute of Law and Economics. So Anne will basically set the stage for our discussants later. The first discussant is Arvid Bell. Arvid will give us what I would call a political science perspective on mediation, and will take us from what can be said as being a binary way of dispute resolution, meaning arbitration is basically the state and the investor, to what I would call a multipolar, multi-party mechanism. Because mediation, contrary to arbitration, is a great tool to involve more of the stakeholders that are actually need to be heard in a dispute between an investor and a state. Of course, this means more complexity, but I think mediation has the potential to actually meet the challenges of that complexity. Arvid is a lecturer on government and director of the negotiation task force for the David Center for Russian and Eurasian Studies at Harvard University. He was also a member of the task force that was held in December 2019 on this very theme, mediation in ISDS. After Arvid, we will hear from Deborah Mazzucci. Deborah will bring to us the experience she has acquired through 30-odd years of work in the mediation field and the dispute resolution field about what it is to mediate collective interests. Because the very specificity of ISDS is that we have collective interest at stake. And Deborah is going to build on her experience in many public groups kind of disputes, including environmental law issues. She has been the past chair of the International Mediation Institute, which has been quite instrumental in thinking about ISDS mediation. And she is also a teacher, a professor, but adjunct professor, I guess, at Fordham Law School on international dispute resolution. Bart Leghem will follow, and Bart will concentrate, and bear with me, this is almost like a French system of going from general to more specific. But I did it on a totally unconscious basis. Bart is actually going to bring to us his very specific experience as a state representative and a state counsel in ISDS cases, and will speak about this one vexing issues in mediation, which is what I call the line of authority. And the line of authority, we know, all of us, that it is very important for any organization. But it is more challenging when a state is actually at stake. And that's what Bart will focus on. Bart is now a partner at Dentons in Paris. And as I said a minute ago, he was also a US government counsel in ISDS cases. But as Anna Joubin-Brett reminded us earlier, he is also one of the two co-chairs with Anna of the IBA working group that produced the IBA investor state mediation rules. So Bart will bring to us all of that experience. At the end of this discussion period, and before we open the floor for a more general discussion, Frauke Nitschke will bring to us this exclusive experience ICSID has actually developed with the new mediation rules that ICSID is proposing. Now, I cannot think of any better person to speak about that, because in fact, Frauke has worked as a PhD student, and she has written a dissertation, which is unfortunately not published, in 2005, exactly on those issues. So Frauke was really the person to basically give us her insights into the field. And although she will specifically address the ICSID rules, I think she has much more to offer than just this, what seems to be a kind of limited topic today. So with that, I will ask Jay to open and give the floor to each of our discussants. I'm not going to take the floor again in between each of the discussants, but hopefully I can come afterwards and lead into the discussion, the more general discussion. Thank you very much.
Thank you, Catherine. So without further ado, I'll just give the floor to Professor Anne Van Aken. Please.
Thank you very much, Jay, and good day to everybody. And thanks to the UNCITRAL Secretariat for organizing this webinar. It's a pleasure and honor to speak to you today. I will now share my screen with you. And bear with me for a second, please. So. Okay, I think now you should see it well. Okay, perfect. So those are actually the stepping stones Catherine was talking about a second ago. And I will talk about the academic forum paper, which was written as a joint work by Catherine and Rona Lee, Lucas Mistelis, and myself. So it's online and you can have a look at it. There are many more details in there. I only have 15 minutes, so I'm going to be quick, but I'm of course very happy for any further questions you may have. So just to quickly let you know what I will be talking about, and it has already mentioned, I mean, it's all about dispute prevention as well. I would then turn to the question on where we stand de lege lata. That was actually a question which I just saw on the chat, so you get your numbers. Some of the case law we know about, and we'll turn to potential concerns about mediation and ways forward. And I think this is also what we will be discussing, and some of the other speakers will take up. So on the question of motivation, is mediation as a dispute prevention mechanism. And if we just like to map a little bit where we are, you see on this matrix basically the national and the international level and the actors who are involved in mediation, so state to state, private to private, and state to private or private to state. So clearly on the national level, state to state is non-applicable, but internationally, state to state mediation has a long history, especially in territorial disputes. Now, nationally, mediation, and I've been following this for years, but there are people, other people might know much better. It's strong, it's getting stronger. And even on the international level, and as we have just heard, it is gaining ground. Certainly the Singapore Convention will foster this even more. But I guess we'll see more private mediation on the international level as well. Now, turning to the state-private level or actors, it is gaining ground, it seems, also on the state level. That's basically about administrative or mediation and administrative issues. The Council of Europe has been working on it for a lot of time, for example, and some states don't do it. They just don't, even within the Council of Europe states, but others do. And as I said, it's gaining ground. Now, the red thing you see is ISDS. That's a gap to fill, but they're slow beginnings. I would like to call it, it's like a seedling in spring, in early spring, and it's the summer is coming, it's growing. And Natalie has already mentioned this one before. So where do we stand de lege lata? And as has been mentioned, so there are mediation provisions in newer IIAs, but there are also cooling off periods in IIAs, and those encourage negotiation before parties can initiate formal arbitration procedures. But they're also a vessel, and they're a vessel for either conciliation, for actions taken by state agencies or by ombudsman, and all those are common in cooling off periods, but they can also open up for mediation. So cooling off periods make it possible already to have mediation in ISDS. Let me turn to those first. So we try to have a look. So how many of those cooling off periods do we have? Now, the UNCTAD mapping project contains no information on cooling off periods, and the WTI, the World Trade Institute in Bern, has an so-called added project, and it did not code cooling off yet. So we decided to do it ourselves, and we did it by supervised machine learning. So we used algorithms on 3,127 treaties, and we took the treaties of the WTI project. So what we found is that at the treaty level, the model identified cooling off period provisions in more than 2,000 treaties. And if we take 2,885 treaties with ISDS related articles identified, this would represent 71% of the treaties. Mostly, predominantly, really predominantly, those cooling off periods are 6 months. There are some with 3 months and some with 9 months, some with a year, but mostly 6 months is used in the IIAs. Now, if we code them on the article level, and we do this because some of the treaties have more than one, then what you find is that more than 2,000 have cooling off provisions, but 4,500 of the clauses do not. So that might be normal, but what you see is that there are some, so it's higher than the number on the treaty level, the article level, and that's because some of the treaties contain not only one cooling off period. Okay. So what's the type of ADR or alternative dispute resolution mentioned in cooling off periods? So it's not mentioned, nothing is mentioned in about 44% of those treaties. Negotiations mentioned in 42, consultations in 10%, conciliation in 3%, and mediation only in 1%. So it's not that it's totally forgotten, and it doesn't mean that if it's not mentioned, it cannot be used. It's just the question of how explicit the treaties are on that. If we look at ADR provisions in IIAs, and that is the UNCTAD database on 2,577 treaties, there are 627 treaties containing a provision for voluntary ADR, conciliation or mediation, no treaty containing a provision for compulsory ADR, and I'm going to come back to that, and 1,813 treaties contain no provision. And as has been mentioned already by Natalie, the newer IIAs contain explicit provisions of mediation, and the list you see below is of course not exhaustive. There might be more and more are coming. Let me just mention the USMCA, CETA, CPT, TPP, as well as the EU treaties which are concluded. Now, let me turn to the case law. This was also a question on the chat, which I have seen. I sneaked in before I put up my slides. In the ICSID system, 12 cases have been reported under the ICSID conciliation rule. That's harder to count for mediation, and I hope Frauke will be able to give you a bit more information on that. So we identified 10 cases. The most common scenario is that mediation has taken place prior to the notice of arbitration. Then there is pre-ISDS mediation or conciliation, which is started after the notice of arbitration has been served. And then there is mediation only, and there the EBA rules for investor-state mediations were used. So you avoid arbitration, or in one case, mediation was used in parallel to pursuing arbitration. So all those possibilities are there. Let me turn to potential concerns about mediation. And what was already mentioned was the investor's view we have on mediation. So that is based on the Queen Mary's Queen Mary University's investor survey, and they have asked how investors view different dispute resolution mechanisms. The dark blue you see is positive, the light gray is neutral, and the dark gray is negative. So positively viewed, not very positively viewed, is the litigation in host state courts, not very surprisingly. Government intervention on the behalf of the investors, also not. Direct negotiations between investor and state are viewed positively by a majority, and slightly higher is actually mediation with 55%. Treaty-based arbitration and contract-based arbitration still have higher positive views. So we need to be aware that there might be, arbitration might still be preferred over mediation. What I found surprising is that they asked also the investor's view on mandatory requirements to mediate before commencing arbitration proceedings. And what you see here is the dark blue strongly in favor, 30%, and somewhat in favor, 34%, which is amazing because that would basically mean two-thirds of the investors have a favorable view of mandatory mediation requirements. And recall please that there's no UNCTAD fund, no mandatory requirement in any IIAs it looks at. So what are other potential concerns about mediation by other stakeholders? So we think that there's a potentially civil society concerns concerning human rights compatibility, since human rights might be implied in investor-state dispute settlement cases, the confidentiality of mediation and potential opacity. From the state side, there might be legislative impediments and as well as impediments in state governance. So mediation may be prohibited for state authorities or need express authority to mediate. And governmental approval processes might be cumbersome. And there might be as well policy impediments, especially concerning accountability of state actors. So problems of confidentiality of mediation, no binding decisions on possibly high sums of money, which you would need to justify to pay to your citizens, need to show that state authorities act in the best interest of the country. One possible solution, and that's open to discussion, could be that there's something like a special independent body accountable to the highest political body or certainly to Parliament, which might alleviate some of the concerns. So one possible way forward would be to have guidelines as how to frame the mediation to make sure it fits the specific needs of states concerning timing, line of authority, and Bart will speak to that, monitoring of the work of the persons participating in the mediation, transparency and adaptation of the confidential parts of the process, and to meet civil society concerns. So one could think about special techniques for reduced confidentiality. Enforcement of the mediation settlement that has been done. So the Singapore Convention would be applicable if there's no reservation made under Article 8.1a. We could think about a code of conduct for mediators, cost and duration allocation, and as has been discussed before in this forum, if there is an advisory center on ISDS that could also have a capacity building function for mediation. I'll stop here and I thank you very much for your attention. I look forward to your questions. And I stop sharing my screen.
Thank you. We've heard the introduction, so we'll just go to the panel discussions. The first panelist for the session is Mr. Arbit Bell. Please, you have the floor, Arbit.
Great, thank you, dear colleagues and dear attendees. It's a pleasure to meet you all. Thank you to UNCITRAL and the Academic Forum for extending this invitation. Looking forward to the discussion. My name is Arbit Bell. I'm a lecturer at the Government Department at Harvard, and I lead the Negotiation Task Force. We are based at the Davis Center for Russian and Eurasian Studies, and we are applying negotiation analysis methods to conflicts all across Eurasia, so from Europe to Asia. And we are asking two questions. So what can a negotiation science tell us about some conflicts that maybe otherwise gets a bit lost? And then what can be done about it? And so one thing we did in December is we hosted an ISDS mediation colloquium where we applied these methods to the question of ISDS mediation. So I want to briefly present some of the findings from our negotiation mapping and then discuss how it relates to this paper that Anne and Catherine and her co-author wrote, which I found very intriguing. So I'm going to share my screen now. Oops, sorry. Okay. So, as Catherine already said, one important thing that we almost took as an assumption very early on was we really have to understand the ISDS challenge not as a bipolar or two-party problem, but as a multipolar challenge. because yes, there are states and there are investors, but there is also civil society or other third-party stakeholders who play an important role. So very briefly, and most of you, of course, are familiar with this distinction. So if you think about three broad approaches that we might have to dispute resolution, and you will see in a moment why mediation is such a beneficial thing to introduce to the problems we are facing, is you can have power-based approaches, think about labor strikes. You can have rights-based approaches, so you take the problem to the court, or you can have interest-based dispute resolution approaches. And this is where mediation and also negotiation comes in. So it's a very different, almost underlying assumption in terms of the tools that you use in order to remove a problem. So I'm going to focus on this because this is also where negotiation comes in. And negotiation always asks one very important question, right? So that's what the great negotiators do. They always ask, well, what do they, meaning the other party, what do they really want? So we often have an intuitive understanding, or we think we have that, of what another party in a conflict might want. So imagine you are an investor, you might have an assumption about what the state or the government wants. And then often you base your negotiation strategy on that, but you may be wrong. And so there are a couple of very common misperceptions. So investors, for example, can overestimate the economic motivation that a state might have. So for an investor, it might be difficult to grasp, but for a state, an issue might much more be about reputation or immaterial factors, or a government or a politician doesn't want to look weak in the face of a dispute, then it really is about monetary concerns. So what negotiation analysis does, you always ask the question, well, what do they really want? What is the underlying interest here? And then we address it. So we applied our mapping framework and this question to the issue of what we call here ISDS negotiation stakeholders. So who are the broad stakeholders? And then we came up with 5 different issues that might be at stake, or 5 different ways how interests can clash. So look at the slide for a moment. So we have the government/state, we have corporation investors, and NGO civil society. And then on the left side, you see relationship management changes to domestic legislation as something that can trigger a conflict. State regulatory or policy shifts, then maybe the worst thing that can happen to an investor, state seizure, nationalization, and finally domestic court judgments. And then we took a couple of cases as an example. So for example, for state seizure nationalization, we looked at Anaconda Copper as an important example. For the regulatory shifts, mostly we looked at the oil and gas sector in Ecuador, Bolivia, Venezuela. For domestic legislation, mostly at Veolia versus Egypt, a domestic court judgment, Ecuador versus Chevron. But we try to sort of take it up one level and think about what are the underlying interests of the stakeholders. And then it looks like this. So for example, for relationship management, which is a very interesting underpinning, we thought for the states is mostly about the ability, about sovereignty. So the ability to implement change and enforce national legislation. You don't want to be perceived as someone who is captured by foreign interests, but you also want to balance that with maintaining a reputation for positive investment climate. So you don't want to scare away all potential investors. For the investor, interestingly, preserving the relationship is also very important. So you want to make sure that regardless of who wins the next elections, you still have a good working relationship with the government. You are not so likely to be interested in a lot of publicity. And you also want to have a predictable relationship. So you want to make sure that next time changes come, you are aware of those. And finally, for NGO civil society, the issue of transparency is linked with the issue of relationships, but we already see why parties have a very different interest in why they want transparency. So it's a very different thing if I am interested in transparency because I believe in transparency as a principle, or if I'm interested in transparency because I want to save face, or if I'm interested in transparency because I believe the public has a right to know everything that's going on behind closed doors. So I don't have enough time to go into the details, but I believe that the slides will be circulated at the end of the seminar. I will also leave contact information in the chat function at the end of my my presentation, and if you want the slides, I can just email them to you. So so we can complete the framework like this, and then boil it down to the underlying core principles. So if we remove a little bit of the clutter, what is going on here. And so you see principles such as sovereignty, reputation, predictable playing field, economic benefits, rule of law. And now we can connect the dots to see where are underlying shared interests. So, and here we see that there are actually some interesting links between dyads of these stakeholders. So both the investor and the states can have an interest in their reputation or in a continuing relationship. Both governments and civil society / NGOs have an interest in responding to changing public concerns. And both the investors and NGOs have an interest in upholding the rule of law. So the moment we move from two-party to multi-party negotiation analysis, or here mediation processes, the more do you see that there is a potential to create value through these shared interests, because it's not really a binary bipolar fight that you are locked into, but you can instead build alliances and bridges across the gap. Another way to look at that would be that's like the same data but just visualized. So imagine you have a state and an investor with these core interests here, and again it's like a very generic approach, of course. So you might think about this as like two different camps, so to speak, and then we can even see which interests can clash and how are these interests more likely being resolved. So what could lead to a court fight, what could lead to maybe even nationalization. But what about the shared interests? So the moment we bring those into the equation, we see that there's something that the parties have in common. So something that they both care about. And if you shift the conversation or the negotiation to those issues, you're more likely to be able to preserve the relationship. And then finally, if we bring the NGOs into this equation, we see that they also connect to a variety of issues and can really serve as a bridge between these two other stakeholders. So what do we learn from this? So we learned that one interesting way to think about mediation in an ISDS context is really to think about it as assisted negotiation, in the way that you help the parties uncover the underlying interests on the other side and help them overcome some of the misperceptions they might have. This also is very important because if you answer this question, what do they really want? You can also address them preventively. So it's much easier, and I think Catherine already mentioned that. So mediation has a preventative character, of course, and the more you know about the other side, the more you genuinely care, the easier it is for you to remove some big obstacles that otherwise can spiral out of control. So long story short, what this tells us is that a careful mapping of stakeholders and their interests in each type of dispute can enable us to identify areas of common ground as well as deep differences, right? It's not all like just happiness. And you can also find linkages to parties outside of the central dispute that could act as a bridge between the main conflicting parties. Now, of course, there are a variety of related challenges. So for example, what does it mean for the codification for some of these mechanisms? And I guess we can get into that later. So I will stop here and thank you very much for your attention. And I will leave my team's email address in the chat box. And so if you have any questions, you can just get in touch with our team. With that, I turn it over to the next speaker. Thank you very much for your attention.
Thank you, Arbit. Just to inform the attendees, all of the presentation materials will be available both in English and French on the UNCITRAL Working Group 3 website once the webinar is over. So you will be able to get the materials on our website. Next, I'll give the floor to Deborah. You have the floor.
Okay, I'm actually having trouble getting my PowerPoint up. Thank you very much. Thank you very much for this invitation to speak before you and to give you some of my experiences in the area of mediation. As Catherine mentioned, I'm just the past chair of the International Mediation Institute, and we have been working directly with CEDAR and ICSID for the last 5 years in developing and delivering mediation training in the context of investor-state disputes. But more relevant to the discussion that we're going to have right now is the fact that for 10 years, I worked within a large financial services company called AIG. And AIG had many multi-party disputes, specifically in the coverage area, where there were many layers and mediation had been used extremely effectively. So part of the conversation we're going to have today deals with how mediation is used in not only the insurance industry, but as Catherine mentioned, in the environmental area. Next slide. So these are the areas that I'm going to talk about. Why do we need mediation for the investor dispute area? How's it being developed? What learning has IMI derived about how and why global mediation is desired globally? I'm going to talk about some other models. The role of the mediator. Everybody thinks that the mediator's role is very linear, but in fact it's not, and it changes from time to time depending on the party's needs and the type of dispute that they're handling. I'm also going to talk about the role of co-mediation, because particularly in large complex cases and where there are multi-parties, mediation lends itself to have co-mediators or other adjudicators involved so that the case can be resolved efficiently. And then finally, I'll talk about my thoughts about rulemaking in the area of mediation. Next slide. So what is it that investors want? Investors want a pragmatic solution and a quick solution to resolving disputes. States need to preserve an image as a good place to invest, so they can't afford a reputation of having investor-state claims. Early resolution of disputes can often salvage relationships and maintain investments. The flexibility of the process can be structured to meet the needs of each case. Remember that the foundation of mediation is trust in the mediators to guide the parties in a voluntary rather than an imposed result. And as we all know, the imposed result that'll end up happening is arbitration. So, you know, mediation has shown that it can deal with multi-party interests and goals in other contexts, and it complements the arbitration process. Because we've seen many models where the neutrals pass off or change their role from arbitration to mediation and then back to arbitration as needed. The next slide. Mediation, we know now, and Natalie has been a major factor here, is an accepted process. If it wasn't accepted, the Singapore Convention would never have really been as successful as it was. We have mediators today working in very many diverse fields, and they're developing skill sets and attitudes and relationships that are really transferable to the investor-state context. We've also seen that there's an openness and acceptability of mediation in the context of country-to-country agreements. The EU-Canada Comprehensive Economic and Trade Agreement is an example of modern BIT, which provides mediation. Increasingly, mediation is being promoted within treaty organizations, such as the ECT, which has developed the Mediation Guide and Protocol for use of mediation. As was noted earlier, we have not seen a great influx of mediation, but in the ECT area, but people are putting their toes in the water, and it is moving in a positive way. Next slide. Most of you know about the Global Pound Conference series that the International Mediation Institute established a number of years ago. There were, it really convened 3,000 participants throughout the world in 24 countries, and it also had an online event. There were many global takeaways that came from these events, and we found a lot of common interests that parties kept on raising. As in the investor-state concept, parties are looking for efficiency as one of their key takeaways. They want a process that will get them to the result as efficiently and cost effectively as possible. They also are looking for greater collaboration between their advisors, something that can really happen through mediation. And they are very interested in pre-dispute protocols, as well as mixing adjudicative and non-adjudicative processes. In this regard, there's a lot of discussion about mandatory mediation, and I always say that that's an oxymoron. Yes, there is benefit to forcing people to the table, but in the end, the result through mediation is in the hands of the parties. No one can force them to make that settlement. The next slide. What we've seen is all of these types of cases where mediation has been extremely effective. In the new Hong Kong core projects, which had to do with the tunnel between Hong Kong and the mainland, they were looking for a very strong mechanism to avoid disputes as well as to resolve disputes. And what they did was set up a panel of experts who would be available to do that, to avoid disputes as well as resolve them. These experts had the qualities of mediators as well as problem solvers as well as adjudicators. And as a result of their fast response when a problem seemed to be coming about, they were able to smooth out and correct mismanagement or other problems. Today we have construction dispute resolution boards in many construction projects, and when we have those dispute resolution boards, they're able to resolve disputes very quickly so that the project doesn't lose money and is delivered on time. Similarly, as I said earlier, in the insurance coverage context, there are many types of disputes that have different levels of coverage. There are surplus insurers, there are excess insurers, there are primary insurers, and how these coverages interrelate is extremely complicated. Mediation has been effective in working with the different coverage levels, and in doing so, they may find that certain levels have collective interests in resolving the dispute. The mediation approach is to actually two ways. Either they will find a global settlement, and then there will be a mediation within a mediation to resolve the proportionate coverage in that layer, or they'll come up with an individual parsing of accountability on the insurance coverage side. These are long processes. They don't happen overnight. It involves a mediator who is going to really focus on the collective interests of the parties at each level and move the case along. In the environmental area, you have to balance the interests of the community with the interests of the state in ensuring a quality environment for the community. In many of these situations, there is the government overlay, and they may not be immediately involved in the dispute resolution, but the mediator has a very important role of, as the settlements or as agreements are reached along the line of selling the settlement to the government or selling the settlement to the community through developing communication strategies and other forms. In this way, the mediator's role changes, but is still the same. The focus is on finding the common interests, finding a way to make that settlement durable, and finding a way that relationships are saved between the parties. Next slide. As I said, the mediator's role therefore changes from educator to facilitator, to devil's advocate. So the mediator has a different role for each. Next slide. Co-mediation is very undervalued in many instances. Some people think of it as doubling the monetary requirement, but in fact, it really doubles the ability to help the parties resolve the disputes. It balances the mediation team and provides trust, more trust. So a number of my slides really talk about the value that mediation can provide. Next slide. So it does provide a model for parties to effectively communicate. Next slide. One of the things that, and I'm just going to end with this, because my time is clearly almost up. Mediation should be flexible and not constrained by rules. This is important because otherwise mediation can be sought, not to de-escalate, but to escalate and create political confrontation. So it's important that rules are not there and a mediator can move from process to process and meet the parties' expectations as well as their needs. I can put my contact information in the chat box, and the slides will be available later. Thank you.
Thank you, Deborah. We impose a little bit of a time limit for our speakers just so that we have enough time for the discussions. I'll just also alert the attendees and the panelists that there is ongoing questions and answers taking place within the Q&A and the chat functions. So you may also look, because there are certain questions posed to the panelists. Now with that, I'll give the floor to Bart to give his presentations. Bart, please.
Well, thank you very much. Let me begin by attempting to get my slides up. It seems that the shares are the slides are already being shared. I'm having trouble getting access to that. 1 second. Okay, let's see, share. Ah, there we go. All right, so mediation in investor-state disputes is an animal that is much discussed, but rarely observed in the wild. I have often reflected on why this is. The answer, it seems to me, has much to do with the specific nature of the state and lines of authority within it. These structural issues have implications for attempts to reform the investor-state dispute settlement system, and I will today briefly explore 2 of those issues. The first concerns the adjustment in attitudes needed for successful mediation. The starting point for many state actors is naturally their everyday world, the one outside of international dispute settlement. In the ordinary world, in the real world, the state has a very different role from the investor. The role of the state and the ministries and authorities that act for it is to carefully consider all of the relevant information and make regulatory decisions for the good of the people. Once the decision is made, those subject to it must obey. That is, after all, the foundation of government. The government governs and the people obey. In the ordinary world, therefore, the investor is in an inferior position. It is one of those subjects of regulatory decisions. The fundamental notion of equal application of the laws to all gives rise to an additional expectation that the investor will not receive any special treatment. Successful mediation, however, requires a fundamentally different set of expectations and relationships. For mediation to work, each party must have an equal right to express their views. Each party must be willing to compromise and take into consideration the position of the other party. Neither party is superior to the other. This requires a substantial change in attitude for state officials participating in investor-state mediation. These attitudes are difficult to change. This difficulty is, in my view, one of the reasons why we have seen so few investor-state mediations in recent years. Now, the second structural issue arises from the organization of the state in dealing with investor-state disputes. Now, before the beginning of a dispute, the state generally deals with the investor through a single ministry or department or authority. If the investment is in a highway concession, the Ministry of Transport typically has full authority to regulate the concession. If the investment is in an oil and gas production sharing contract, the Ministry of Hydrocarbons has that authority. When a dispute arises, the responsible ministry usually has the authority under national law to modify its measures and resolve it. If the investor invokes its rights under an investment treaty, however, the situation immediately becomes much more complicated. In today's world, most states have designated a specific ministry and often a specific office within that ministry to represent it in investment treaty disputes. Once a notice of investment dispute is filed, the ministry in charge becomes the one responsible for investor-state disputes. So the ministry that adopted the challenged measure remains in the car, but it is no longer in the driver's seat. Moreover, in many governments, there are a number of ministries that closely follow and provide input into investment policy and investment disputes. So when I was counsel for the US government in investment disputes under the NAFTA, may it rest in peace, I had to clear every written brief by 7 different federal agencies in addition to the state, local, or federal department responsible for the measure at issue. Now, not every state has as elaborate an internal process as this, but the immediate result of a notice of dispute is generally the involvement of a new decision maker or decision makers from other ministries that are unfamiliar with the investor, with the measure, or with the dispute. This has 2 follow-on effects. The first is delay. Time is required for the new players on the state side to become familiar with the case, brief senior policymakers, and begin to take a position. This does not facilitate early resolution of a dispute. It represents a serious challenge for an ISDS system that anticipates successful mediation of disputes before arbitration is initiated. The second implication is that settlement is more difficult. As a general matter, the more decision makers required to make a decision, the more difficult it is for them to achieve consensus. Now, there's already a certain government dynamic that makes settlement of high-profile disputes more difficult. If an official decides to settle such a dispute, he or she is exposed to potential second-guessing, accusations of corruption, or criticism that would not be presented if an arbitral tribunal imposed a decision on the state. The multiplication of this dynamic with the involvement of multiple ministries does not make dispute resolution through mediation any easier. So in conclusion, the nature of the state and how it operates does make a difference. ISDS mediation must find solutions to these issues if it is to be as successful as we all hope. And with that, I will conclude my presentation and invite the moderator to invite Frauke Nitschke to join us.
Okay, you have the floor.
Thank you. I'm pulling up my presentation. Can you see the slide? Could someone confirm?
Yes, we can see it.
Great, we have overcome the technology challenge. So before I start, let me first thank the UNCITRAL Secretariat for such a great note. The document 190 really looks at alternative dispute resolution and dispute prevention in from many different angles. And of course, we know from the introduction and from those of us who have worked in this field that the Secretary, Anna Joubin-Brett, has been a big supporter in this and has also seen investment disputes from different angles as counsel and arbitrators. And of course, we need to acknowledge here the work that the Secretary for Justice, Teresa Cheng, has done, especially in the context of investment mediation capacity building. Debbie had mentioned it, the CEDR, IMI, ICSID, and Energy Charter Secretariat Conference, cooperation in delivering and developing training, bringing government officials and mediators together. So from what I've learned in the times that I've worked on international investment dispute settlement is that you need three things. You need good communication in the eyes of the disputing parties, patience, and some humor. And with that, let me try this. Wang Shanghao, Zhuangying Lei Wu Jia. Dobry dzień, dobroyo utro y zmevo doma. Buenos días y bienvenidos a mi casa. Saba el keir mahaban bekam fi beiti. Bienvenue chez moi. Good morning, good afternoon, good evening, and welcome to my home. So when we start out, let's look at the, I cannot move my slide. Hold on. I'm sorry, my slide is frozen. Does it work now? Can you see the slide with the ICSID overview?
Yes.
Yeah, very good, thank you. So ICSID, most people associate ICSID nowadays with investment arbitration, but I wish to recall that the center was really created for dispute settlement, investment dispute settlement in the 1960s for member states and nationals of member states using conciliation and arbitration. And that was expanded in 1978 on the side of the disputing parties as well as on the process side. Nowadays, we also do other activities, administration of other cases, state to state, regional secretariat for trade agreements, which are listed in the green. We've heard from the paper already a lot about mediation. Natalie presented it, the development on the Singapore Convention on Enforcement of Mediated Settlement that is intended to also apply to investment disputes. The guide on mediation should be added here. Certainly, it's a very practical tool developed by the Energy Charter Conference. And then data from ICSID arbitration. And that is really what brought me into thinking that maybe we should look at a different process than investment arbitration. When I first started at ICSID, I worked on institutional matters and had the pleasure of working as a research assistant to our then Deputy Secretary General and was in charge of statistics, which we now publish under McInerney's leadership. And so we see that on this slide, this is from all ICSID cases, ICSID arbitration cases concluded at December 31st, 2019. 35% of all ICSID cases settle or otherwise discontinued. Now, if we break that down a little further, you see in yellow the settlements and discontinuance on the right, and in blue the rulings of a tribunal. So 15 and 1% on the top in blue, those are awards on jurisdiction or considering the claim manifestly without legal merit. That leaves you with 49% of arbitrations where a tribunal actually decides the dispute on the merits. So in other words, in less than half of the arbitrations, there is a tribunal determination, which brought me to think what Arbit so aptly described is what is it that the parties really want, and what we've heard earlier also about the mindset of the parties. So maybe there would be benefit in offering a different kind of process that brings about the settlement faster than within the context of the arbitration. So in 2018, we proposed to the 155 ICSID member states. We recently welcomed a new member to the ICSID family, Djibouti. So we proposed to our members a set of mediation rules because we've heard from our states that they would like to mediate more disputes, but what they needed or what they were looking for is a trusted forum with credibility where they can mediate and engage in these kind of facilitated negotiations that investors and states, as Debbie mentioned, are really interested in. We provide a party-driven process in the mediation rules. It's flexible, allows for tailor-made solutions with the idea that this is cost-effective and time-effective dispute resolution. And of course, we work together with our friends at the UNCITRAL Secretariat to ensure that the formal requirements in the Singapore Convention are also integrated in the ICSID mediation framework should parties wish to avail themselves on enforcement aspects of the Singapore Convention. Now, ICSID mediation is entirely voluntary, so that means not only do the parties need to agree to the mediation, but unlike other ICSID dispute settlement processes, either party may unilaterally withdraw at any time. So I call this ongoing consent throughout the process. Unlike other ICSID dispute settlement frameworks, the mediation rules also provide for assistance by the Secretariat to transmit and offer to mediate to the other side. We know that within the UNCITRAL context, there is, on the terminology side, conciliation and mediation are used interchangeably. Given that ICSID has these different frameworks, we have the difference in terminology. And I just want to point out a couple of differences in terms of process from conciliation. So the mediation is more widely available. We'll look at that on the next slide. On disputing party access, there's no jurisdictional objections within a mediation framework. There's no 3-member commission, and there's no report at the end. So what do we offer? So you see on the slide the scope as envisioned in Mediation Rule 2 to authorize the Secretariat to administer mediations that relate to an investment and involve a state or RAIO. And you of course need the written consent to submit such a mediation, have it administered by ICSID. This slide gives you a process overview. So it starts with a request for mediation, a registration or refusal, and then the appointment of 1 or 2 mediators. Debbie has touched upon that. So co-mediation, where we do not have a 3-member adjudicative body. Then parties will file brief written statements describing the issues in dispute and the parties' views on these issues. This is not intended as a pleading. The mediator then holds a first session with the parties to determine what we call the protocol. So that sets out various procedural aspects that the mediator then discusses with the parties. As Debbie mentioned, and I fully agree, if you want to structure a mediation process, you need to give the flexibilities to the parties and avoid over-regulation. At the same time, if you have a dispute with sovereigns, as Bart mentioned, there are many people involved, many agencies involved, so there is a certain kind of formality that helps to keep the process on a good track, and so that is why we have that protocol. And termination then can happen on in different ways: the signing of a settlement agreement, the withdrawal of a party, or other ways that are indicated on the slide. General provisions, we have cost. Each party bears half of the mediation cost and its own cost. Confidentiality is regulated as a principle in the mediation. And I just want to mention here that we included this provision on the mediation rules for confidentiality based on the feedback for states. What I hope we can reframe the discussion around confidentiality in investment disputes, and that is not that nothing comes out of a conciliation or of a mediation, but that there are strategic communications that the parties agree on in terms of when to release the information and in terms of what time. And that these are aspects that are addressed at the first session. And you see that in the first exit conciliation, in fact. The parties there agreed on a joint press release, the text of which was brokered and then provided to the public. Of course, the mediation rules have a without prejudice provision. This is not uncommon in the exit system. You already see that in Article 35. And that brings me to how do you integrate the mediation into the current framework? So you could either do this as a standalone process, parties agree to these, to apply these rules, or combined with other processes. And what we've heard about is you could have it prior to an arbitration, possibly within a cooling off period, or maybe closer to the dispute even before a notice of arbitration is filed, or mediation in parallel with an exit arbitration. One couldn't envision that the arbitration is suspended and then the mediation is ongoing. And then the parties could, should they reach a full settlement, discontinue the arbitration and terminate the mediation with a settlement, or they could resume the arbitration and request the tribunal to embody such settlement in an award, which would then benefit from the simplified enforcement mechanism in exit convention settings. We had a question on the chat that I thought was really interesting, whether parties to an exit arbitration could, in their procedural order number 1, agree to appoint a standing mediator to address certain issues that occur or come up in the context of the arbitration. And that is something that is a creative way that I had not thought about, but I think that is certainly possible. The answer is yes. The parties, much like document productions, where there are, for example, processes regulated that the parties should first exchange documents and only the disputed aspects are submitted for a decision to the tribunal. This could also include a mediator on other aspects that were listed in the chat. The other advantage, should parties try to do a mediation in the ongoing arbitration, is that even if partial settlement is reached, that may significantly reduce the number of issues to be decided by the tribunal and therefore help with time and cost savings. What are we doing in 2020? Our state consultations continue, and we aim to have the mediation rules adopted as soon as possible. We still offer administration of investment mediations. I know there was a chat question on that. We have not had an official investment mediation that we have administered at this time. What we have had is multiple cases where parties have asked us to assist with facilitation of negotiations directly between the parties. Mediation capacity building. I fully agree with what the UNCITRAL Secretariat collected in document 190 and also what we have in the academic forum paper. Capacity building, I think, is a very important aspect. And I believe that there are a lot of opportunities for capacity building that already exists. I mentioned already the investor state mediator training that we've held in Hong Kong, Paris, and Washington, and we'll be working on a virtual version for the new normal. But then there are also training for government officials with our friends at the IFC, at the World Bank's one of our sister organizations at ICSID that look at problem solving and really assisting investment promotion agencies and government entities to deal with investment disputes even before a notice may be filed. Technical assistance workshop, ICSID has done these on dispute prevention and management in Vietnam or really in all other areas around the world. And of course, dissemination of information on mediation, such as webinars. We did one last week together with our friends in Singapore and UNCITRAL as well. And we will do one together with the IMI, CEDAR and the Energy Charter Treaty Secretariat in July. So with that, I say thank you, merci, shukran, gracias, jeje, and spasiba.
Thank you, Frauke. I think with regard to the capacity building, there is a comment in the Q&A section on how to ensure inclusivity and diversity in the capacity building, which we also, I guess, aim to achieve. Now, there is a lot of ongoing discussions in the Q&A and on the chat. But before I go to those questions and answers, I'd like to give the floor to Catherine to kick off the discussions, please.
Well, thank you, Jay. This has been a great part of our webinar this afternoon, and I want to thank personally all of the presenters and discussants. I have basically two questions that are kind of, I find, difficult questions. Perhaps my first question, and I would like to ask Bart if he would be willing to answer it, and then any other person on the panel. As a mediator, and I think as having listened to a lot of parties in mediations, what we find very useful is the flexibility, is the possibility to craft the mechanism to the very specifics of the case and the specifics, and Frauke reminded us of culture. I mean, we are in international disputes, hence the culture of the people around the table will be different. So mediation has this capacity of taking that into account. Now, my question first to Bart and any other who would like to pick it up is, by drafting rules, aren't we taking out part of the beauty of mediation, which is the flexibility, which is the adaptation? So I think the border between rules and certainty that rules gives us and the flexibility is very, very difficult to maintain. So if Bart wants to pick up that, and again, any other after that. And my second question is about how, and this is linked with the capacity center, with the center that would be used as a capacity builder. How do we share experience? Because everybody said statistics is very meager. We have difficulties in finding actually what's going on the market. So how do we get real experience, and that we can talk about those real experience? I saw the recent ECT statistics. Out of 130 cases, 9 settled. But I asked the Secretariat and nobody could tell me why and how those 9 cases settled. Whether there was mediation or not, we don't know. How mediation was used, we don't know, and so on and so forth. So these are my 2 questions, and I hope we'll have many others. Bart, would you like to take my first one?
With pleasure. So if I can paraphrase it, the question is, do we really need rules for investor-state mediation? And the answer to that is no, we don't really need rules, but the rules nonetheless serve, in my view, and of course, be interested in Anna Joubin-Brett's views on this as well, if she wants to express them. In my view, rules serve two really important functions. So the first function is education. Governments are very rule-oriented institutions. And for them to buy into the notion of mediation, it's very helpful to have something that describes in very concrete terms what the process looks like. So, and it's also important to remember that in many parts of the world, governments are not involved in mediation. Most Ministry of Justice officials don't do mediation on a regular basis. So it's one function is education. The other thing is, if you look carefully at the mediation rules, like the IBA investor state mediation rules, what you'll see is that they're not really rules in the same sense that a set of arbitration rules is. They don't constrain anything. All they do is they describe issues that the parties and the mediator should think about in getting to the point where you have that first meeting between the mediator and the parties and decide how it's going to happen after that. But there's nothing that describes what's going to happen after that. There's no kind of constraints on how the process is going to unfold. And the parties, of course, have full authority to derogate from any of the rules that are expressed there. So that would be my answer.
Well, thanks a lot. That's very helpful.
Maybe I could add to that. That is exactly what we tried in the mediation rules. When you look at the rules closely, you will see that a number of rules deal with the institution, and there are very few rules that actually deal with the process. The idea is to find a balance with giving this framework in an international setting that states and investors have trust and credibility in, while then educating. These are the things that still happen in a mediation. What we often hear is the issue that mediation is a bit of a myth. This is a negotiation that we rather shouldn't get in. If we get in, this is weak and it's not clear how it works. And so that is what we try to do, this education piece, to provide a bit of a matrix of how a process would look like and how does it differ from other dispute settlement mechanisms.
Well, thanks a lot. Arvid, you have
just one sentence to build on what Bart said. So I agree with you, and I think there's even an additional counterintuitive thing, which is from a politician's perspective, right? If you're representing your government, you might actually prefer losing arbitration or losing a legal case over losing in a negotiation, right? So if you can go back to your people and tell them, well, we tried everything we could, we fought it, but we couldn't get what we want, that's easier than going back and saying, well, I'm a bad negotiator, or we sat down with them and we didn't get our preferred outcome. So maybe the challenge would be to preserve or to establish the kind of basic objective criteria around how mediation could work, so that there is some framework that is transparent, that people understand the steps, but you don't take it all the way towards rigidity and dictated outcomes so that the parties feel they're deprived of agency.
Okay, Jay, it's your turn to get all the questions from the audience.
Okay, I think one set of questions was addressed to Anne in the academic paper, which Professor Anne has already responded on whether the list of perceived obstacles in the paper is exhaustive. And I think she has replied that they're not. There are other obstacles which have already been reflected in the comments as well, and on the future work of the academic forum as well. Now, there's also a question that Anne wanted to reply live. I think that's the compulsory mediation clause found in the FTA between Australia and Indonesia. Anne, you have the floor. Would you like to answer that live?
Actually, it was my mistake because I didn't know which one to press. So I didn't really want to answer that live. I cannot answer Luke's question on what's the explanation that it has been included in one and not in the other treaty. I really cannot. It's speculation. So sorry for that.
Okay, I think the comment by Luke was in fact referring to a clause between the FTA between Australia and Indonesia, which has a mandatory mediation clause, whereas the same clause was not found in between the treaty between Australia and Hong Kong. So if there was a number of notions with regard to compulsory mediations and whether that actually works. And if any of the panelists would like to take the floor on the notion of compulsory or mandatory mediations, do you have any comments to make?
It's Bart.
Yeah.
I'll bite if nobody else is. So I think one needs to think as to what it means, mandatory mediation. Under the IBA investor state mediation rules, agreeing to the rules requires the parties to go to the first meeting with the mediator. That's all they have to do. They have to show up, listen to the mediator, listen to the mediator's description of the process, how he or she engages with the parties. And then if either one of them wants to say, bye, this was fun, see you in arbitration, then they can do that. And the same is, I think, true under most rules. So for example, even the existing ICSID conciliation rules, a party can at any point make clear to the Conciliation Commission that they're not interested in resolving the dispute. And if they do that, then the commission is obligated to issue a report that finds that this dispute can't be resolved. So what it really means, I think, for most sets of mediation rules, subject to the views of my co-panelists, is the parties have to show up for the first meeting, and if they don't like it at that point, then that's all they have to do.
May I just say on this very point, compulsory mediation, if we mean by that people that are forced to stay in a room to negotiate, it doesn't work. I mean, mediation is highly consensual. So what the mediator must do is remind everybody that if they are in the room, even though they were compelled to come to the room, once they are in the room, their utmost consent is absolutely necessary in order to do a good job.
Would anybody else want the floor on this question? Now I think Gaston from Cameroon had asked for the floor. Would you like to speak? You have
Gaston,
to unmute
you are
yourself.
on mute. You have to demute your computer. Yes,
Can
here you
you
are.
hear me now?
Yes, we can hear you.
Hi, everybody. Thank you, Anna. And I wish to thank the Secretariat for this very interesting initiative. Anna has said something which I find very interesting because I shared that opinion. She has said that arbitration might still be preferred over mediation. And from my personal experience as mediator or conciliator, my impression is that for more parties, mediation or conciliation is usually used as a bridge to reach arbitration. Mediation is not yet, to my humble opinion, apprehended as an accurate means to settle investment or commercial dispute. And now my question is, do you think possible that in a near future, arbitration be considered, mediation be considered as arbitration? And if yes, how do you think this can be done? This is my question. Thank you.
Anna?
Is that a no, Anna, or you want to? Oh,
not,
here you are.
Not at all. Not at all. No, I'm glad to jump in. I'm not supposed to, but if directly challenged by Gaston, I cannot but answer. No, you're asking me a question which for me is obvious. Yes, I strongly believe in mediation. I strongly believe that this is a very credible and viable means of settling disputes. I've been working on this mediation, this animal, as Bart calls it, in the context of investment disputes for many years. And at least one thing we can say we have achieved is that those who were rolling their eyes are now enrolling in investment mediation courses to become investment mediators. So to me, it tells you something. It's also clear that mediation is not yet at the stage of arbitration in terms of information that is available. But I mean, Gaston, you have been in this area for many years, and you know that 15 years ago, we were wondering, we had no count of the number of disputes. We didn't know how many cases were going to what forum and what were the outcomes of these cases. And this, thanks to transparency, a lot has happened in arbitration. Mediation is very much still in the confidential mode, and therefore there is very little known about mediation. But I think when you start talking to either counsel that have been assisting states or government officials, you will see that in fact there is a lot more mediation going on, taking place and being successful than we actually imagine. And I can take the example of some countries that are very actively engaging in mediation, be it Georgia, as we were reminded recently, or Egypt, that has also been very proactive in the settlement of the disputes that resulted after the revolution. And you can see that a lot of government officials see the merits of mediation because it allows them to find a settlement, but without being completely in the air, as Bart was mentioning, the fact that you can protect yourself with a set of rules and with a process that is officially enshrined in a framework is very helpful for government officials wanting to engage. So you're asking me, is it going to evolve, and are we going to know the same growth of mediation than we have of arbitration? Maybe not to the same extent, hopefully not, because that would mean that disputes are increasing, but definitely I am a strong believer in mediation in the context of investment disputes.
Jay, can I speak to that issue? There are two services that are out there. One is dispute resolution data, and the other is arbitrator intelligence. Yes. And they're collecting information about how either arbitrations or mediations are resolved. There are subscription services, but they're starting the process. The other thing that we can't overlook is that once people experience mediation, and don't look at it as just resolving the whole dispute, because sometimes mediation is used to resolve pieces of the dispute. Mm-hmm. And that helps make the dispute resolution process efficient. So case studies have to start to be written. And the issue of confidentiality, the parties can still talk about, the dispute and the process. They may not want to talk about the resolution, but they could still talk about the process that was used, and we could derive some good examples and case studies if people would talk about how the process worked for them.
Yeah.
Okay, yeah.
Yeah, I can maybe add something. It's really a lovely question, Gaston, because that is what we need to answer for the future. So I think based on data that our colleagues from the World Bank have gathered, it looks like from all the investment grievances, only 7% of these issues actually come to arbitration or in some form of public forum. And the data also shows that around $100 billion in investment projects are lost for investments leaving the countries. And this does not include the lack of investment expansion. So there, I think we only see the tip of the iceberg in the official numbers on arbitration. So there, I think the mediation offers a much broader tool for economic development that could be used earlier on. The second piece there is look at the arbitration data. You have 40%, sometimes close to 50% of arbitrations that actually settle after the arbitration is filed. And that, I think, supports what Bart has shared with us from the perspective of the US and more generally, that something happens once the arbitration is filed. You have someone in charge, and it does not seem to be in all countries that this is also that this being in charge already happens at the notice stage. So if you have a structural piece in a country that is in charge, the 190 document refers to Peru, other countries do it as interministerial commissions, other countries in their organization, it works better if it's an informal group of government officials that work together. That is a piece. And to me, the other aspect is, there was also a bit on the chat, is domestic legislation. To me, it's not so much about whether it's prohibited or not, but empowering the state to engage in settlements. Because we see from the arbitration data, it is possible. What we're trying to do is to move the settlements earlier in the process and get more of that. So.
Thank you, Frake. So let's go to some of the discussions that were taking place in the chat and the Q&A. I think there was an interesting discussion between Arbit and Liz on the analysis that Arbit gave on how, whether the systemic interests and the case-specific interests may differ, and how the long-term and the short-term interests are reflected in the analysis that Arbit gave. Maybe you might want to elaborate on that. And there are also questions to Frauke on whether there was a need to enforce any of the settlement, mediated settlement agreements in the exit context, and how can disputing parties make use of the exit mediations, whether the treaties have to refer to the exit mediation rules, or what are the mechanisms there. So I'll first give the floor to Arvid to maybe elaborate a little bit more on the analysis and the different interests to be reflected.
Yeah, so Lise Johnson had a great question. Unfortunately, I do not have an answer because it's a very tricky question, which is how might you have to adjust your party interest mapping if you're taking different timelines into account, and also how interests might change over time. So an investor or state might have a very different preference when it comes to the immediate short-term solution to a problem, and then a broader perspective. So I think it's a great question. It's probably something that requires further analysis. It just speaks to the notion that in negotiations in general, and something that mediators have to be aware of as well, interests are not set in stone, right? So they can change. There can be a new government, there can be different economic circumstances, there can be external factors that impact the calculus. And so one should not get too married to a specific position that you believe might be accurate for a longer time frame. So I don't have an answer to this, but I think it would be very interesting to expand this negotiation mapping and also think about broader systemic questions where there are more immediate challenges.
Yeah, sure. I think what Arvid brought up is a really good point that you see in the investment context. I think if any of us would have thought in 2004 that Argentinian cases are going to be settled, we didn't think that that may happen. And then fast forward a few more years, things do change over time. If I may paraphrase, so what I understood from the question is how can the exit parties consent to the mediation rules? And it's a great question. I presented the mediation rules at our state consultations in November, and we had a 90-minute discussions on mediation rules with very specific questions from state representatives. How should we word our clause in the treaty? How do you want to word it? If we look at the arbitration experience, that should tell us that the more specific the reference to the rules is, the better. But I also think that a confirmation of agreement that mediation means exit mediation, should we receive a request for such mediation, I can see that that should work for registration purposes. The question on the enforcement, I think, is a really good one. I've thought about this for a while. I think that the enforcement of mediated settlement, the Singapore Convention, is really a milestone, also for the investment context. But perhaps not so much on the actual enforcement at the end. From what we see in the exit context, I put to you the settlement statistics. Out of those settled arbitrations, which are maybe 500 by now, we've had about 4 cases that actually came back as an investment arbitration arising out of that settlement. So while we don't know whether council included an exit clause in their settlement agreement should issues arise, that number may indicate that once you reach a settlement in investment disputes, that settlement is generally complied with. But, and if you wanted as a party to ensure that the enforcement option is there, you know that under current rule, arbitration rule 43.2, parties can submit the settlement agreement to the tribunal and request the tribunal to embody that in the award. And we talked about earlier that the mediation framework is much broader than convention and additional facility. But if you have 2 disputing parties from exit convention states, you could benefit from the enforcement mechanism in the convention. What I want to add here is that statistics have shown, and Debbie may know more about that from the IMI perspective, that now that we have the Singapore Convention, I think there is also much more buy-in at the beginning of the process. That okay, I may engage in mediation, and if I have a mediated settlement, I have a tool for enforcement. And I believe there's an IMI survey out there that indicates that 84% of general counsels working in companies with more than 10,000 employees are much more likely to use mediation if there is an enforcement mechanism. So this was before the Singapore Convention. And so I think that those are the points that come to mind on the question.
Thank you, Frake. I think Mark Appel had raised his hand to take the floor. We do need to close in a few minutes, so if you can keep your comments very short, and then we'll give the closing remarks to the chair of the working group. Mark, please.
Actually, a quick comment and then a question. The comment was really to approve what ICSID has done, really in recognition of the growth of mediation, which is to say, mediation isn't something that must take place before arbitration is contemplated. It goes to Lucas's question in the chat. To I think it was a gentleman posed a question before about, is it just another step to be to delay the process? So if parties can mediate concurrent with a arbitration proceeding at an appropriate time when they're ready, isn't that a better way to approach the process? The second is really a question for Bart, if he's still with us. And what I was going to ask for was his reaction to the ECT model instruments. Oh, there you are, Bart. ECT model instruments provision for a intra-ministerial commission. The obvious is that it adds for addressing investor-state disputes. The obvious is it would create more people to say yes, but it seems to me the political risk issue gets addressed much more effectively by that approach. But I would love to hear you had direct experience, so please.
No, I fully agree. And there are some examples of countries like Morocco that have had a ministerial level commission that deals with investment disputes and has the process for resolving them before they go to arbitration that have been quite successful. So I think that's a welcome innovation.
Thank you for that. I think it's time to close. I'd like to give the floor to the chair of Working Group 3, Shane, to give his closing remarks, and then we'll stop there. Shane, please.
Thanks very much, Jay. Now, I'm not going to summarize for all in the way that I normally do at the working group, because of course, now is not the time for a summary. These webinars have been informal discussions, and they are really, in a sense, helping us to start the discussion once we get to our working group sessions in, hopefully in the fall. So I'm not going to offer a summary, but what I did want to do is offer a note of thanks. As Anna noted at the very beginning, this is the last in this series of webinars organized jointly by the Academic Forum and the Secretariat. We have worked through a number of the papers and side events that had been prepared for our postponed April session. We do have several more webinars upcoming. As Anna mentioned, there is one on the Code of Conduct jointly with ICSID, as well as one coming up in early July on the topic of reflective loss. However, this is the last in this current series. It may not be the last, of course, of the webinars that we do. When we have the chance to meet in the working group again, we are going to have to discuss whether we want these webinars to continue, in what format they might be, what topics they might cover. That will all be for the working group to discuss. But for now, I wanted to say a note of thanks, particularly to Malcolm. And I'm not sure if he has joined us again, but as the lead of the Academic Forum, he has done a tremendous amount of work in organizing these webinars. To Anna, Corinne, Jay, and the Secretariat for making sure that these webinars happened. And of course, to all of you, participants, panelists, speakers, those who asked questions, those who participated so actively in the chats. I am extremely grateful for this. These webinars have been informal, but as I hoped, informative. And that is because of your participation. And so I'm quite happy that even though we have to be physically apart at the moment, that we have found a way to continue our discussions together. This is a good thing. It is a success. And of course, while these don't replace the working groups, and I hope to be able to meet in the working group soon, and whether that is in person or through some other means, we do hope to meet as a working group soon. I feel that after having this series of webinars, and I'm sure we'll feel the same after the upcoming ones organized differently as well, that our discussions at the working group will be enriched for sure by these discussions and by all that we have learned, and that is the point. And so it is with that that I offer my thanks to everyone for participating over the course of the last couple months in these extraordinary times, to all for their flexibility, especially those, including our distinguished rapporteur, who I'm sure the evening grows quite late in Singapore now, and to all those who have participated in various time zones around the world and making themselves available. So with that, my thanks. And now I hand it back to you, Jay. Thank you.
Thank you, everybody. I think our thanks also goes to the Academic Forum for hosting these webinars. And we hope to see you in the upcoming consultations on the Code of Conduct, as well as the webinar on the reflective loss and shareholder claims. So with that, I'd like to close the session. Thank you, everybody, for joining.
Thank you, everybody.
Thank you.